Council, we ready to proceed? I don't ever get a chance to ask that because we usually come in from out there, but this is a time set for oral argument in our case number CACV 22055, Marsh versus Atkins. Council, first of all, I apologize for calling the case a little bit late today. We had a hiccup with prior oral argument, and hope you can understand that. At least when I was in practice, it has happened to us all, and it happened to somebody this morning, so I appreciate your patience. Each side is allocated 20 minutes for argument today. Appellant can reserve a portion of your time if you wish to do so for rebuttal, but if you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask, and to avoid embarrassment, I would ask that all present make sure your cell phones are turned off so our proceedings are not interrupted. We've read the briefs, we've conferenced the case. We'd encourage you to keep that in mind as you present your argument today. Our proceedings are being recorded and will be posted to YouTube in due course, so please, as you begin your argument, tell us your name and the party that you represent. With that, Mr. James, you may proceed.
Thank you, Your Honors. Norman D. James with Fenimore Craig in Phoenix, representing the appellant, Dr. Timothy Marsh. This is the facts here, and I won't, obviously they're discussed in the briefs. I won't spend too much time given the limitations on time today, but they do present a very unusual situation here. Dr. Marsh, who's an experienced geologist, applied for 2 prospecting permits. He actually applied for a total of 18, but the others are not relevant to this case. So I'll focus on those 2. He applied for 2 prospecting permits. I do that because they used to be called prospecting permits. They're now mineral exploration permits. I'll call them permits. He applied for 2 permits in September of 2019 in Pima to explore land in Pinell County. 10 months later, the department issued decisions denying the applications. In both cases, very specific grounds for denial were given. Dr. Marsh filed timely administrative appeals of those 2 permits. While the appeals were pending, the hearing was delayed to allow for settlement negotiations. We were able to settle some of the disputes over other permits, but not the 2 permits at issue in this case. Ultimately, hearing was set for March 17, 2021, St. Patrick's Day. About 2 weeks before the hearing, we were advised by the land department that the grounds given for denying the 2 permits were erroneous, and therefore there was no reason not to grant the permits. However, there was a first right of refusal that the surface owners held, and I should back up here just so it's clear for the record. This was a case where the land had been sold to a mining company, CR2. I believe we have the patent in our appendix, but it was sold in 1995, subject to a mineral reservation, which is required under Arizona law in connection with all sales of property by the state. So there was a severed mineral estate. Under Arizona law, the fact that the minerals are still owned by the state allows persons to apply for mineral exploration permits to explore for, and if they find valuable minerals, develop that deposit, subject to, again, a lease and payment of royalties and so on to the state. So we're now about 17 months from when Dr. Marsh filed his applications. This was the first time the right of first refusal, or excuse me, it's called a first right of refusal in the statute, came up. We ended up proceeding to hearing. There were letters from the surface owners from the 2 parcels indicating they did wish to exercise their first right of refusal. The administrative law judge, Thomas Shedden, took evidence, heard testimony from the parties, ultimately issued a decision in which he determined, I think correctly, that once the department had determined that the grounds it gave originally back in July of 2020 for denying the two applications were erroneous, that at that point the application should have been granted and the permits issued. And
Counsel, I have a question. So
Sure.
what is the basis of your position that the permits should be issued as the remedy for the agency's failure here?
Okay. The reason is very simply there's no dispute. What happened here was, again, to be a little more specific, once the grounds for denying the permits, Your Honor, became a non-issue because the agency admitted that they were improperly denied, the agency determined that it was in the best interest of the trust to issue the permits. And the plain language of ARS 27-251B says that I've got it here, I can quote it. If the commissioner finds that issuing the permit is in the best interest of the trust, the commissioner shall issue to the applicant a mineral exploration permit for the state land designated in the notice.
So when does the first right of refusal come in then?
Well, that's the key issue here, Your Honor. That's right. But
I understand that.
yes, and the problem here is the first right of this first right of refusal is a statutory right. And again, in fact, this whole case really boiled down as a matter of statutory interpretation. The right of first refusal doesn't come into play in the sense of trumping, and I think this is the mistake that the Superior Court made. It doesn't trump everything else that goes on here. The Superior Court basically said that as long as there's a right, this first right of refusal floating out there, we have to recognize it. Our position is no, it's a statutory right. It's not a property interest. It's not a contract interest. It's created by an Arizona statute. And there are multiple reasons why, under the facts in this case, Your Honor, Dr. Marsh should be entitled to receive the permits as the administrative judge held.
Okay, so the statutory right then doesn't mean very much if someone can get in ahead of you. It's really not a first right of very much.
Well, the first right, it really becomes a question of harmonizing, I think, ARS 37-231E, which contains the statutory right. It's a single sentence. That's all that we have. We don't have regulations on it. We don't have a substantive policy statement, Your Honor. Harmonizing that with the requirements in ARS 27-251 that governs the issuance of these permits.
But isn't there a regulation that speaks to that statute?
Yes, there are. The Land Department does have regulations addressing that statute. The regulations do not address the first right of refusal.
But doesn't one of the regulations, and I apologize I don't have it on me right now, but doesn't one of the regulations say that an application provides no more rights than someone who hasn't applied, and therefore, as we weigh the balance of interests here, the property owners or the patent owners have a higher interest or more of a right, because it's statutory, than the applicant?
I would disagree for multiple reasons, Your Honor. I think, first of all, as we talked about in our brief, and let me just go through the list here. There are a number of reasons why I think Dr. Marsh should be the prevailing party here. First of all, as we talked about, the agency's process violates a number of provisions in Title 41, Chapter 6, including the Regulatory Bill of Rights, including the statutes.
Well, and I'm glad that you brought that up. I want to hear more about how it violates the Regulatory Bill of Rights, because the way I read the Regulatory Bill of Rights is that you have to have a notice and opportunity for hearing. And didn't that happen when you had the hearing at the Supreme Court or the Superior Court?
No, the Regulatory Bill of Rights requires that when an agency makes a decision that denies an application filed by a citizen, they have to provide written notice that describes the basis for their action.
But didn't they do that after Judge Shedden's decision when they overturned that?
And that's the mistake, Your Honor. It's not, you don't get notice after the fact. You get notice. They gave us notice, as Judge Shedden determined. They gave us notice. They said, we're denying your application for various specific reasons, and then they later said, no, those reasons didn't apply. At that point, they should have granted the application.
So is it your position then that the final agency action was before Judge Shedden's hearing, or was it after when they issued the denial?
Well, it's the final decision that was appealed to the Superior Court was obviously issued after Judge Shedden's hearing. But a person who's applying for a permit from an agency can't properly challenge that decision unless they understand the grounds for the decision. It goes even more broadly, which is, I think, in part, Your Honor, what these statutes do. It goes more broadly to the notion of post hoc justification for a decision, that we're denying your application on ground A, but later we decide, well, that was pretty weak and we're about to go to hearing. Here's ground B, we're going to deny your permit anyway.
So is it your position then that the final agency action here that's appealable under 41-1092, that the Administrative Procedure Act, was the original denial before you went to hearing with Judge Shedden?
No, I think technically the final decision has to be the decision issued 2 months later, because unless we have final agency action, we can't go and we can't challenge that under the Administrative Review Act.
Okay, thank
you. So we're not trying to argue that the original decision was the final decision. What we're arguing is under the relevant provisions of Title 41, including the statutes, Your Honor, that govern administrative appeals to OA, which is what happened here. Again, the agency has to disclose to the permit applicant the grounds for its decision. And here they disclosed one set of grounds, and then after admitting those grounds were in error, came up with a completely different basis for its decision. And we're arguing that violated at least 3 different statutes in Title 41, as well as the general principle that agencies aren't allowed to change their mind later, because obviously it creates an unfair situation. But if I can continue down the list, to back to your original question, aside from the violations I just talked about, it also, the position taken by the agency here violates the plain language of ARS 27-251B. That provides, as I read a moment ago, that the commissioner shall issue the permit if it's determined to be in the best interest.
But, Counselor, you have to read statutes in harmony, and there's a statute that allows for the first right of refusal. So, if you have a property owner or patent owner who is unaware of the application, in your view, they're just out of luck.
Well, I think that raises several different issues. I mean, one of which, who is responsible under the statute for providing the surface owner notice? The department takes the position it has responsibility for doing that. We're not necessarily disputing that, but it's not clear from the statute. The statute is at best ambiguous. It's one sentence. There's no regulation that fleshes out what's supposed to happen. But more to the point, I think that you're driving at, Judge Howe, the point here is that how do we make these statutes fit together? And the logical way to make them fit together is not to force an applicant like Dr. Marsh to go through this entire process, spend 10 months on an application, spend another 7 months appealing a decision that the agency admits is erroneous. Then the right of first, 17 months into the process, the right of first refusal is triggered. For example, suppose they hadn't admitted that the grounds were erroneous. We appealed, we ended up in the Superior Court, we ended up here before you. And you agreed with us at that point and said the grounds are erroneous. Does the right of first refusal get triggered at that point? It makes a lot more sense, Your Honor, if you're going to harmonize the statutes, to make that determination up front, and certainly before you get to the end of the process and the agency says yes. I mean, their argument boiled down, the state land department's argument is, when we don't do anything until we determine it's in the best interest to issue the permit to Dr. Marsh, and then then we contact the surface owner.
Well, it may very well be that the agency should have done things differently, and someone should have notified the owner of the application, but if the fact of filing the application and the agency's determination defeats the owner's right, then there isn't much of a right at all. I don't see how interpreting everything that way gives proper oomph to I admit it's one sentence, but one sentence can mean an awful lot.
The way, as we've explained in our briefs, I guess, and this is really the last point, it's been a little choppy, I apologize for that, but I think the way that you can easily harmonize these two statutes is if you look at 27-251B, it logically breaks into two steps. The first step is to determine whether the land covered by the application is open to application. That's the term in the statute. And that notification has to come within the first 45 days. Hey, it may take longer if the agency's busy, but there's this initial step where you advise the applicant, you advise Dr. Marsh, is the land open to application? And it seems very obvious that that should be the place where this right of first refusal comes into play, because either there's a prior application, a senior application that's already pending, and you can't, the application has to be, it isn't denied, it simply can't go forward because the land isn't open. Or, to your question, Judge Howe, what happens at that point is you notify the surface owner and say, we have an application covering the surface, covering the mineral estate of the property where you own the surface. Are you interested in exercising your right of first refusal? If the surface owner says no, you proceed with the application. If the surface owner says yes, they file an application, and you tell Dr. Marsh, sorry, Dr. Marsh, the surface owner is used his right of first refusal. But you don't wait, you don't do it at the very end of the process, particularly after, again, the plain language of the statute said you issue the permit if it's found to be in the best interest of the trust, and that's what happened here. So it simply creates an illogical situation, Your Honor, where you're actually creating a conflict unnecessarily. If you do it up front, make that determination up front, then I think the two statutes actually mesh together pretty well.
Counsel, one quick question for you. Ownership of the bundle of sticks for this property was a matter of public record before your client filed for an application, correct?
Yes, Your
I
Honor.
mean, this is not one of those circumstances where whoever was required to give notice, if notice was required, didn't know or couldn't find out who that person or thing was.
In fact, the deeds are in the court record, but yes, there are deeds. The deeds to both surface owners show the mineral reservation, so it's there. And in fact, on the smaller piece, the 160-acre piece, that piece was actually sold in July. Again, 10 months after Dr. Marsh filed his application. So certainly it's of record. The surface owners were aware of it.
Well, maybe to follow up with this question, doesn't that mean that Dr. Marsh should have been aware, hey, there's an owner out there who might jump ahead of me on this?
Well, I think what Dr. Marsh assumed, Your Honor, was that because the application proceeded and there were decisions that were issued denying his applications on completely different grounds, that wasn't an issue in this particular case. It would have come up earlier. So, if I may reserve my...
Very well. Yes.
Thank you.
Mr. Jacobs.
Good afternoon, Your Honors. Assistant Attorney General David Jacobs, representing State Land Commissioner Lisa Atkins in the Arizona State Land Department. Just simply, the Arizona State Land Department did not violate Arizona law. The Land Department acted exactly as required by state law. Instead, appellants asked this court to require the Land Department to violate state law by ignoring a clear statutory obligation of the Land Department to offer the first right of refusal to the surface owner.
Okay, so how do the statutes harmonize?
Sure, I can get right to that. So we're taking one statute from Title 27, which deals with mineral leases, and one statute from Title 37, which deals with state land generally, and and specifically in this instance, the sale of state trust land. So please note the similarity of the two provisions I'm about to read. 27251B states, upon application, if the State Land Commissioner finds that issuing the mineral exploration permit is in the best interest of the trust, the Commissioner shall issue the applicant a mineral exploration permit for the state land designated. That's what appellants are relying on, excuse me. ARS 37231E2 states, the Land Department may issue, upon application, mineral exploration permits embracing the reserve mineral rights when such issuance is deemed in the best interest of the trust. So both of them seem similar. We're on the same page there. The best interest of the trust determination is coming first. To harmonize them, we have to go to the remainder of 37231E2, which was enacted in 1992 after the two provisions I just read. It states, provided that the surface owner or owners shall have the first right of refusal to acquire such mineral exploration permits. It seemed pretty clear to me that the process is a party applies for a mineral exploration permit, the Land Department can grant that application if it finds it in the best interest of the trust to do so, but the surface owner must have the first right of refusal to acquire the permit. I would say appellant's interpretation, as suggested by the bench, erase that final proviso entirely so that the Land Department has no such obligation and the surface owners have no such right.
Counsel, let me ask you, if I heard you right as you began, it was a statement that the department did sort of everything right here. It strikes me the notice was tardy. And I don't know that matters, but it strikes me that things maybe weren't done perfectly here.
I would say that if we're talking about notice of the department's reasoning, which I believe is what you're asking.
Actually, I'm asking, after Dr. Marsh applies, he should have gotten written notice by the 15th of October, 29. So it's in two buckets, and I want to understand the state's position on both those buckets.
Certainly. The first bucket is, right, upon an application, there is the requirement about the state getting back to the applicant, basically, and asking for a rental payment if the applicant wants to proceed. The department did not meet that deadline. I guess I don't have a good explanation for that. It actually, it imposes a burden upon the applicant, and the question is whether there's a benefit to the applicant to doing that, but that's not on the record.
I read the statute differently.
Okay.
I read the statute that says that once someone applies, the department has to go through, their determinations, and part of that is determining best interest and whether the, statutory provisions are met or not met. And that is all supposed to be done before there's ever a rental payment or a bond issued. Are you saying that it's different than that and the process is different than that?
I would say that the provision 251 of 27251 does suggest that the department makes a determination and asks for a rental payment, and then they go about the rest of the determination about best interest of the trust and whether they're going to grant the permit. So that second part was not violated because there is no deadline, as Judge Kiley found, for the best interest of the trust.
But I'm going to stop you right there because you say that there's no deadline, and you plead that throughout your pleadings. But under Title 41, and it's chapter, Article 7.9, Chapter 7.1, it talks about statutory timelines that every agency is supposed to adopt in terms of, administering their regulatory scheme. And I have found nothing where the state land department has adopted a regulatory timeline for determining best interests. And it can't be that the legislature meant that you could sit on something forever and not determine a best interest until the agency just determines it's the best time to do so. So I'd like you to talk about that a little bit, because the argument that the best interest determination can take however long the agency determines that it should take is just ludicrous to me.
Okay, so the regulatory timeframe, the argument from the land department's perspective is that it's a different type of license we're talking about here. It is not actually a license, it is a permit to use state trust land. And we would argue that under the Arizona Constitution, the Arizona Enabling Act, that right cannot be granted unless the state land commissioner determines it's in the best interest of the trust. And she is granted great discretion in making that determination. The land department has not created a regulatory deadline. I don't believe this is a situation where it went on forever. I mean, it took 7 months for the first decision to be made by the commissioner. There was discussion with appellant's counsel about whether that was correct. It took another 10 months to get to a reversal of that in the commissioner's mind. But I think the point of it not having a deadline is some of these issues are just very different one to the next.
And I think I understand that, but my point is if the agency determined that they needed a year to make a best interest determination, they have every ability to propose a rule and enact it through the regulatory review process and enact a rule and say, it's going to take us at least a year to make these determinations. It's going to take us 2 years for whatever reason, and you go through the regulatory review process and put that on the record so everyone knows what the timeline is. But the agency has never done that and just takes the position that the best interest determination can take however long it determines, and no one's on notice what that means.
Well, they're not on notice by regulation. The application advises the applicant that is what's going to take place. There are discussions during the application process which fleshes out the complexities of the situation or not. I mean,
so the application said that it could take however long we determine possible for our best interest determination?
You're completely correct that there was no timeline given, but it does say that the land department is going to take a multidisciplinary approach to assessing what needs to be assessed to determine whether this application is in the best interest of the trust.
Thank you.
So they will gather all the information necessary. It's not all within the department's possession. In this case, there were water issues involved that had to come from DWR. There were issues about local, and in this case, there were both city and county jurisdictional issues among the 18 applications. Some were within the city, some were without the city. So there were many requirements that, frankly, the land department just does not have possession of all the information. They have to gather it. And sometimes they have to gather it from the applicant as well. We go through, there's an application, it is fairly bare bones, but as the land department has concerns or not, they may ask for more information, and I guess there could be a way to stay the deadlines, but that is not really the process the department's doing. They're proceeding to understand what's in the best interest of the trust as quickly as they can, given the resources they have available. And that is what they have at the moment.
Thank you.
So then let me go back to, so I think, Judge Thumma, the only deadline that wasn't met was that original deadline. They did not issue the 45-day notice and the rental requirement. After that, they made a best interest of the trust determination, they made a written order.
So any time in this process, then if the department notifies the owners, then they can get their first right of refusal in. Their right always exists at all times. Then.
Exactly. I would argue that, appellant argues this is a post hoc determination. This is not post hoc. If anything, it's pre hoc. It existed the entire time. As you said, The property records are public records. They're readily available. I can pull it off the internet today. The statute is readily available. The requirement is there. It says, provided that the surface owner shall have the first right of refusal. So that requirement was always there.
It seems very inefficient, though, to have, to go through all the difficult process that Dr. Marsh and other applicants have to go through to get the permit granted, and poof, the owner shows up.
So let me give you a little context, and then I'll directly answer your question. So this requirement applies, in this situation, it's a mining company. Sonoran Copper Company, the surface owner is a mining company. Well, what's the big deal to them? This requirement of first right of refusal applies to every owner of state trust land, their surface rights. It's a statutory obligation. We're talking multi-billion-dollar semiconductor manufacturing plants, hospitals, resorts, individual homes. So coming from that perspective, that is what the legislature seems to have been protecting, the right of those people to have the first right of refusal. Why doesn't it come earlier? That's the way the statute is written. The statute is written that the commissioner makes the best interest of the trust determination, and then the surface owner shall have the first right of refusal. In a sense, from an efficiency standpoint, the land department also has applications for parcels that are going to go to auction. The applicant does all the groundwork. They put out the money to have the appraisals. It's reimbursable if they don't win, but they might not win. I mean, it's a devotion of time and resources that they do. That's a state process. The kind of motivated applicant is the applicant that proceeds, and if it's something that would be granted, then the surface owner has the right to do so. To make, a resort or a hospital proceed with the application just because some applicant filed the application, I mean, that's not what our first right of refusal is. That's basically forcing the surface owner to become the applicant. The first right of refusal, that's a concept where if the transaction is going to take place, then the possessor of the first right of refusal can come in and substitute itself for the entity that was going to close the deal. Otherwise, it allows applicants just to put a burden on the surface owner to proceed with an application that they might not be interested in proceeding with.
So is the funding of a benefit, is it that the mineral rights, that it's to the benefit of the state to have them used, regardless of whether Dr. Marsh does it or the owner does it, or is the benefit tied to the particular person or entity who wants the permit?
Whoever gets the permit has to follow the same requirements. So if the surface owner ultimately decides to exercise the first right of refusal, the surface owner has the same statutory requirements as Dr. Marsh would, which is a certain amount of expenditure on exploration, certain reports. If they don't do the exploration, there is a cash payment essentially that is required. So the surface owner would step into the shoes of the applicant.
We take as a court cases one at a time. But what you have just described suggests to me that applications like this happen all the time. In a variety of different contexts, we are asked to see how geographically remote statutes fit together. It would strike me that there might be room for a helpful regulation to help folks down this path. I know that's not our bailiwick, but if a case can be avoided as opposed to resolved, we're all better for it.
I could see advising the land department that of a better way to do this, but I think we should also remember this is an odd procedure. The land department didn't think it was in the best interest of the trust. Listened to appellant, got additional evidence, changed its mind. These two particular parcels were the last two. There were 18 applications. It was kind of a rolling 10 were agreed upon, then 4, then 2, and then these were the last two. These also happen to be the only two where the surface owner had the right of first refusal. The others are not, were currently still state trust land. They were maybe leased but not owned by a purchaser. We are 2 weeks before the hearing before Judge Shedden. ready to go. The land department maybe could have issued another piece of paper, and Judge Shedden could have been reviewing that piece of paper. He seems to, in his recommended order, the lack of a written explanation was, I think, the actual basis for his decision. I think the parties just wanted to go. And in the sense of, did appellant have a fair chance to argue this? That's the only thing that we've argued the entire time, because by the time we got to actually going before Judge Shedden, all the issues about what was in the best interest of the trust had been conceded. So we were only talking about whether in that case the land department had to offer the first right of refusal to the surface owner. That was what was argued before Judge Shedden. He said based on the procedure, no. Then we went to Judge Kiley. He said, that the first right of refusal trumps any procedural problems that might have existed. So, in the normal course, I don't know that this type of situation would come up as often, if at all. I think, probably the appellant would just have received something that says first right of refusal, and then they could have challenged that.
Well, to your point, we've looked pretty hard to see if there's another case like this one, and I have yet to find it, so.
No, and I think, actually, to go back to Judge Foster's point, there are just not that many cases. So, when we're talking about the regulatory timelines as applies to the land department, there's just really not a case that states that apply to the best interest of the trust determination. I would argue it gives the department a lot of discretion to do it right. That's the most important thing. That's what the Constitution requires. It'd be a breach of trust to allow a disposition of property interest that was not in the best interest of the trust. So arguably that's why there is no timeline for that. Excuse me. So I think, apologize, my memory's not so great without reading, make sure I'm talking about what I need to talk about. So I guess one other point, and maybe counsel softened their stance about the notice required to the appellant, to the surface owner. It's both hard to imagine what a first right of refusal means if the surface owner doesn't receive notice, and it's also, you're talking about, again, the full context of what we're talking about. We're not talking just about mining companies along the surface. We're talking about every former landowner. To not provide them with notice, at least that there is an mineral exploration permit application that is about to be granted, really provides them with no right at all. Again, a first right of refusal isn't, oh, you never asked me if I was going to sell the property, so therefore, you didn't exercise your first right of refusal. The possessor of the first right of refusal has to be notified of it. That is absent from appellant's analysis as well.
And you concede that it's the department's obligation to provide that notice?
Absolutely. And it is easy for the department to provide the notice. It is difficult for every surface owner successor to continually look and see if an application is pending.
Mr. Jacobs, one final question from me is there anywhere else in statute other than the Administrative Procedure Code that governs the process here in terms of the administrative process of review? I just want to make sure that we're getting everything that we should. Is there anywhere other than the Administrative Procedure Code that we should be looking?
I think if we're talking just of the review of what the land department did, it's the Administrative Procedure Code and whatever can be gleaned from Title 27 and Title 37. There's no state land department specific regulation that governs this.
Thank you.
So I guess if there are no further questions, I'd just like to say that the court must affirm the decision of the Superior Court to preserve the surface owner's rights, to allow the land department to issue valid MEPs in the only manner authorized by Arizona law. Thank you.
Thank you, counsel. Mr. James, rebuttal.
Thank you, Your Honors. Just a couple things very briefly. For what it's worth, the statute we're talking about that contains the right of first refusal was actually enacted in 1968, so it's been around for a long time. And remarkably, this has never come up before. I don't know why. Second point, Judge Hill-Foster, to you asked some questions. A license is broadly defined in the Administrative Procedure Act and includes permits. So, as you know, issuing a permit is a licensing process, and it's subject to the requirements in Title 41 that govern licenses. In the limited time I have left, I'd like to again go back to this notice issue and the nature of the right of first refusal. And again, to put some context in this, when we were in the Superior Court, we argued in our opening brief that the agency wasn't required to give notice because the statute itself doesn't say that. There's no regulation that says it. And frankly, we thought we were doing the department a favor. We were saying, you don't have an obligation. They came back and said, yes, we do, and it's actually very easy for us to satisfy it. We do this sort of thing all the time. So we did. In our reply, said, okay, that's fine. If you can do it, there's no reason why you can't do it in that initial 45-day period, instead of forcing applicants to go through an 18-month process or longer, as I said earlier in the hypothetical I raised. So, you know, the issue here isn't whether the department has to give notice or not. They've conceded they can do it, and it's easy to do it. The problem is, again, as we talked about, forcing the applicant, like Dr. Marsh, to go through this entire process, file an appeal, hire an attorney, file an appeal, engage in settlement negotiations, and on the eve of hearing, have the rug pulled out from under him, to be blunt. Again, to conclude, this is a statutory right. It's not a contract right. It's governed by and subject to the requirements of other Arizona laws. That includes Title 41. It includes the provisions that govern the issuance of these permits. So, in our view, having made a finding, to conclude, having made a finding that was in the best interest of the trust to issue the permits to Dr. Marsh, you should vacate the decision and remand with instructions to tell the agency to issue the permits.
Counsel, thank you.
Thank
We
you.
appreciate your arguments today. We appreciate your written briefs. We appreciate your accommodating the schedule as well. We will take the matter under advisement and we'll issue a written ruling in due course. Court stands adjourned.